Hey everybody, and welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. This is the Facebook page where you can join us if you're fighting foreclosure yourself. There's lots of us that are willing to help each other, and that's what we do here. We help each other out. Today we're going to talk about Carrington's case, since it's so interesting, and what's going on with it. His latest is that they filed a motion to dismiss, and he's going to file an opposition to their motion to dismiss and attach an affidavit to that. Let's take a look at his affidavit. Affidavit in support. And this is in the Eastern District of New York. This is his federal case where he's going after them for RICO, racketeering. So it basically states affidavit in support of defendant's motion to dismiss. Of opposition to motion to dismiss. I, William Carrington, being duly sworn, hereby state the following. I am the plaintiff in the above captioned matter, and I am proceeding pro se. I respectfully submit this affidavit in opposition to defendant's motion to dismiss, which was filed on, he's going to file it. He hasn't filed it yet, so that blank is there for him to fill out. And it says, I am retired New York police officer with extensive experience in investigating and understanding criminal activity, including patterns of racketeering and other illegal conduct. As someone who has been trained and has worked in law enforcement, I have full understanding of how criminal organizations engage in patterns of fraudulent behavior. My background provides me with the knowledge to recognize the signs of RICO violations, and I am confident that the actions of defendants in this case fall squarely within the scope of racketeering under federal law. Defendant's motion to dismiss asserts that plaintiff's claims are barred by res judicata, collateral estoppel, and the Rooker-Feldman doctrine. However, these arguments are without merit and should not bar my claims, which are grounded in serious allegations of fraudulent conduct and violations of federal law, including forgery, fraud, counterfeiting a promissory note, and the Racketeer Influenced and Corrupt Organizations, or RICO Act. Plaintiffs' claims are based on fraudulent actions of the defendants who have engaged in a pattern of racketeering activity involving the submission of forged promissory notes and fraudulent representations in both state and federal court proceedings. This conduct constitutes a violation of 18 U.S.C. 1962 which prohibits individuals associated with an enterprise from conducting or participating in its affairs through a pattern of racketeering activity. The defendant's conduct includes the submission of multiple forged and counterfeit promissory notes to the state court, which were used to support a fraudulent foreclosure action. There are at least 3 forged notes in the state court docket. In addition, 2 other notes introduced at trial that were falsely presented as the original note. Each of these notes bears different forged signatures, indicating a deliberate and organized effort to deceive the court and other parties involved in the proceedings. In addition to the submission of fraudulent documents, the defendants, including their co-conspirators, engaged in a pattern of misrepresentation and concealment designed to further their fraudulent scheme. This conduct is part of an ongoing pattern of racketeering activity designed to unlawfully take property from unsuspecting homeowners, such as myself, through fraudulent foreclosure proceedings and deceptive legal tactics. The RICO statute is intended to address patterns of criminal activity carried out by enterprises, and in this case, I contend that defendants' actions, including the fraudulent submission of forged notes and false statements to the courts, clearly meet the criteria for a RICO violation. My claims are grounded in the racketeering activities of the defendants, which extend beyond the mere facts of a single foreclosure action. These actions involve multiple fraudulent representations and actions by various parties with shared criminal objective. Further, defendant's motion to dismiss improperly relies on the Rooker-Feldman doctrine, which does not apply here. I am not seeking to overturn or appeal the state court's foreclosure decision. Instead, I am asserting claims that arise from the fraudulent conduct of the defendants. which involves racketeering activities under RICO and violations of other federal statutes, such as the Fair Debt Collection Practices Act, the Truth in Lending Act, TILA. These claims are entirely independent of the state court judgment and do not require this court to review or alter any prior state court decision. Attached hereto as Exhibit A are copies of the forged promissory notes filed in the state court docket, as well as other supporting documentation that shows the fraudulent nature of defendant's conduct. These documents illustrate the deliberate efforts to conceal the truth, mislead the court, and execute a fraudulent scheme to unlawfully obtain property. For the reasons outlined above, plaintiffs' claims for violations of RICO, fraud, and statutory violations under FDCPA and TILA should proceed. These claims are based on documented acts of fraud and criminal conduct that fall squarely within the purview of federal law. Dismissing these claims at this stage would not only be premature, but would also unjustly prevent the proper investigation and discovery into the defendant's racketeering activities. Therefore, I respectfully request that the court deny defendant's motion to dismiss in its entirety. Allow these claims to proceed to discovery and provide any other relief deemed appropriate. The racketeering pattern established in my complaint warrants thorough investigation and adjudication, and I respectfully ask that the court ensure that these claims are heard of on their merits. I declare under the penalty of perjury that the foregoing is true and correct. And this is an affidavit that he would sign. Okay, so let's look at the exhibits. Exhibit A, forged promissory notes. So let's take a look at this. This is also in the court docket. SEMA note, NYSEF, Exhibit G, document 58, pages 25 through 27. And this is what it looks like. It says consolidated adjustable rate note on the first page. And this is the second page. But it's the third page that we really want to look at is this signature here. And this is the signature on the third page. As you can see, this does not look like his typical signature. So we want to know what's the next note look like in comparison. And this is the next one, which is also in the NYSEF docket on page 40 through 42, Exhibit G. That one kind of looks like the other one, but it's not identical. All right, and then we can see this is the signature. Again, that looks completely different from the first one. And as you know, there can only be one promissory note, folks. So, if you see other signatures on your promissory notes, then you know they're forged because there can only be one. And then the last one, SEMA note, Exhibit 1, Doc 17, pages 19 through 21. Here's the first page, which has a barcode on it, which the other ones don't. Looks like they redacted some information here where the loan numbers are. And then you can see this signature is also different from the other two. And then there's also close-up inspections of page 3 of each forged note. Again, this one is the first one, the second one, and the third one. Now you guys know that none of these look the same. They all look completely different, which is proof of forgery. And again, since there's 3 versions, it's also proof of counterfeiting. Let's take a look at what the legal definition of forgery says. AI says, forgery is the crime of creating or altering a document or signature with the intent to defraud. It is also considered a white-collar crime. So, elements of forgery: creating a false document, altering a document, writing a signature, and fraudulent intent. And examples of forgery: signing someone else's name on a document, which is what they did. So you're saying that these are definitely forged documents. Forgery is what they did. And then you can look at the definition for counterfeiting. It's a little bit different. Counterfeiting is the act of illegally copying or imitating an item and passing it off as the real thing. Okay, and that's what they're doing with these promissory notes. They're saying, well, this is a copy of the original note. No, it isn't. How can you have 3 different copies of one note? Again, this is absolute proof of fraud here. So, anyway, guys, I thought y'all would be interested in seeing what's going on with his case. And if you guys have any questions about this video, you can leave them in the comment section below. And as always, everyone have a blessed day.